and welcome to everything. Just give us a second here. We are about to hit it. Yep. We're all good now. That's awesome. Yep. Today we're going to be talking about the ATF and what they are doing with their dumbass self because they always do something stupid. We have a 9-page brief that they filed in response to the National Association for Gun Rights. The National Association for Gun Rights sued over the FRT thing. And this case is known as NAJR versus Bondi. The plaintiffs in the case filed a notice of noncompliance with the court saying, hey, the ATF had a deadline to return all these triggers. They missed the deadline and they're not returning the triggers, and they are still prosecuting people for owning these triggers.
Oh, no way.
And yeah, imagine that, right? Imagine that. I am going to set a super chat goal. Whether we get it or not doesn't really matter, but I will set it anyway because I'm maybe losing my job. I did get a job offer to go for 3 months out of the year for a lot of money to Antarctica.
So basically, in 3 months, you would get a year's really good year's salary.
Correct.
You just wouldn't see your kids.
Yeah.
Or any other humans except penguins.
There are people there at McMurdo Station.
Or polar bears, not Antarctica.
No. Where McMurdo Station is, you don't see any it's wildlife. But yeah, whatever. But I'm not doing that. So we're gonna go ahead and jump into this because
okay, the Sentinel got it. He knows what my background is.
No, well, no. The one of the things that they said was you need a background check.
No, I meant my background, my virtual background.
Oh. Okay. All right, let's go ahead. I'm going to I screwed up here. All right, that's better. All right, so let's go ahead and read this whole shabacle here. Rich, do you want to go?
Sure, yeah. Response to the plaintiff's notice of noncompliance. Defendants respectfully submit this response to plaintiff's notice of noncompliance, ECF blah, to address plaintiff's assertions. The defendants have violated this court's July judgment as modified by the court August 2024, blah, as detailed below. None of plaintiff's assertions have merit. That's like the ultimate middle finger. First, plaintiffs assert defendants did not complete the return of all seized FRT 15s and WOTs by February 2022-2025, notice blah, but defendants have developed and implemented a process for returning FRTs and WOTs as quickly as practicable. Defendants have been transparent with the court and plaintiffs regarding serious I have no idea what that word is, administrability difficulties, including I think I got to do something with a dog. I got to run. I'll be right back. Sorry.
All right, I have no idea where he was. Including difficulties in determining which owners are members of the plaintiff organization and entitled to return of the devices and resource constraints. One of the things that the order says is the return of all FRTs. It did not specify the plaintiff organizations or just the people. It said return of FRTs. The notice of compliance. Indeed, defendants repeatedly provided notices of these logistical difficulties to the courts, explaining that the ATF continues to face the same administratively concerns as outlined in its stay motion. as to February 22nd deadline for return of the unidentified members. Okay, basically they said, oh, it's impossible for us to return all these. And the court said, well, you got them, so just return them.
Well, hold on a second, John. I mean, if law enforcement seizes something, they just like throw it in the back of the pickup truck.
No,
we got another one, Bob.
No, they have a list of everything.
And you mean there's like documentation, like seized from Richard Hughes, address 1 Main Street?
Yeah, let me get done reading this paragraph first. And as the defendants have explained, plaintiffs could have accelerated the process by conveying defendants information about the members that they claim to represent who seek to return pursuant to the injunction. It did not only apply, it applied to everyone for one thing. For another thing, they want NAGR to turn over the members list, which absolutely should not happen. Having refused to do so, plaintiff stated concerns about the time defendants need to return the device under the only approach available rings hollow. All right, keep on going, Rich.
Second, plaintiffs disagree with the need and possibly even the legality of running background checks prior to return of seized FRTs and WOTs to eligible individuals.
Yeah, okay, let me just explain that. When you contact them, say, hey, I want my trigger back, they're like, okay, but we're going to run a 4473 on you. Like, we're going to run a NICS check on you.
It's a trigger.
Exactly.
It's not a firearm. But this court unequivocally excluded individuals prohibited from possessing firearms from the scope of its injunction. The injunctive relief shall not extend to any individual prohibited from possessing firearms according to background checks prior to, whatever, and FRTs, WOTs necessary to ensure that the defendants do not return these devices to individuals prohibited from possessing. Wow, I can't talk. From possessing firearms as this court order contemplated. Third.
I'll read the next one. Third, plaintiffs take issue with the defendant's refusal to return FRT 15s and WOTs in states where those devices are illegal under state law. But this court orders do not require the ATF to aid and abet violation of state laws. And the plaintiffs do not attempt to argue otherwise. Instead, plaintiffs speculate that the defendants should not be trusted with interpreting the laws. I 100% agree with that, by the way. 100% agree with that. Notice F4, suggesting that the defendants will incorrectly construe state law as prohibiting FRT 15s and WOTs to retain these devices, which happens. I can almost guarantee you that will happen. But the plaintiffs offer no basis to believe that defendants are misinterpreting state laws in this manner, and they are not. Besides history, indeed, 16 states recently filed amicus briefs, which wasn't allowed, by the way.
Okay, I get how this works. I'm getting it.
An appeal from this action claiming FRT 15s and WOTs violate certain of those states' laws, and that states will incur costs to enforce those laws against owners of the devices. But that possession of FRT 15s and WOTs violates certain state laws is therefore not ATF's own legal analysis. It is the conclusion supported by sworn declarations from state law enforcement officials in this very litigation. Okay, let's go. Let's read this. If we, the people, treated the ATF the way that they treat us, we would have been all shot, along with our pets, a long time ago. Guy asshole, 100%. All right, yeah. So basically, the amicus brief, the states tried to intervene in the case. The court said you can't intervene, and the state said, okay, we can't intervene, but we're going to intervene anyway, and submitted a brief. All right, go ahead, Rich.
You want me to read or comment?
Either one.
All right, so boy, this is rich. Fourth,
yeah, exactly.
Plaintiffs claim that defendants continue to rely on legal classification of FRTs as machine guns, pointing to 2 criminal prosecutions in the United States District Court of Puerto Rico. But as defendants have explained repeatedly, prosecutions and other enforcement actions are not taken on the basis of any legal classification because ATF's classification does not carry binding legal effect apart from the statute. And one of those prosecutions does not even implicate the FRT at issue, but I guess the other does. Noting the United States argued that the FRTs at issue in the case might be different from the FRT 15 or WOT.
The Alamo 15 got enjoined. Even if that's the case, the Alamo 15 got enjoined from being reduced because it was a knockoff of the FRT 15.
Moreover, this court recognized that the defendants could continue to prosecute violations of the National Firearms Act by limiting its injunction prohibiting criminal prosecutions to the individual plaintiffs and their families, or the organizational plaintiffs and their members, and the downstream customers of any commercial member of an organization to the extent that it does not interfere with other courts. Final judgment at 2. This specification would make no sense if defendants were enjoined from any criminal prosecutions against all individuals through the United States, and plaintiffs do not argue that either of the 2 prosecutions identified in their notice involved individuals covered by this court's permanent injunction.
The permanent injunction said you can't prosecute people for FRTs. They're playing fast and loose. They're what the government's trying to do. The
ATF. Let's make it clear on that.
The ATF, what they're trying to do is they're playing fast and loose with the whole entire thing. I'll bring up the final motion, right, and then we're gonna we'll look at that in a second. But let's just keep on going with this.
Okay. The Fifth Circuit's decision, however, does not alter this. That the case acknowledged a challenge to an agency regulation is necessarily a challenge to the underlying statute as well. But plaintiffs here did not challenge an agency regulation. Instead, they challenged application of a statute to a particular type of device, explaining action seeks declaratory and injunctive relief to defendants' arbitrary and capricious and otherwise unlawful efforts to misclassify forced reset triggers as machine guns under National Firearms Act of 1934. Accordingly, this court's conclusion that FRTs and WOTs are not machine guns does not preclude application of the criminal statute prohibiting possession of machine guns to individuals who possess different devices and in any event fall outside of the scope of the court's injunction. That's a mouthful and kind of complex to understand. All right, you want to scroll?
Yeah. We will scroll down to 5th.
5th, plaintiffs argue that defendants must return all seized force reset triggers, not merely seized FRTs and WOTs, but this court's ruling considered only FRTs and WOTs. Both FRT and WOT operate the same principles as those devices focused in the plaintiff's complaint. The complaint also is full of references to the FRT 15 manufactured and sold by.
Scroll down.
Rare breed triggers. And as this court's emphasized, the statutory definition of a machine gun is solely concerned with the mechanical operation of the trigger. Order at 38. Accordingly, because different types of forced reset triggers may mechanically operate in a different way, and because there are no standards for designation of a device as a forced reset trigger, this court only had occasion to consider the mechanics and rule of the legality of the FRT 15s and WOTs. Holy cow, is that a loophole? You got to get a microscopic whatever to go through. Defendants repeatedly made clear that they understood the court's orders as concerning only those devices. Notice ATF destruction. The ATF destruction branch was also instructed not only to destroy any FRT and WOT devices in their possession. Explaining, ATF notified its Office of Field Operations that any FRTs and WOTs related recall efforts targeting individuals or entities named as plaintiffs or known to be members of the associational plaintiffs should be stopped. Response to plaintiffs' notice of noncompliance. The court preliminarily enjoined ATF from undertaking certain enumerated criminal enforcement regulatory actions related to the FRT WOT forced reset triggers. Field counsel, is instructed to advise that any enforcement activities related to FRTs and FRTs and WOTs against individuals or entity must be stopped if the person is not prohibited from possessing firearms. Defendants reiterated that understanding shortly after the court issued final judgment. The record here contains seven separate ATF investigation reports or other documents, including that the FRT and WOT, the two devices plaintiffs specifically placed at issue, are machine guns. And describing reasonable efforts undertaken by ATF to comply with obligations to return FRTs and WOTs, identified members of under the court's orders. Discussing this court's vacatur of the ATF classification of FRTs and WOTs as machine guns, at no point over the course of these filings, which date back to 2023, did plaintiffs ever raise concerns with defendants or the courts regarding ATF's understanding of the scope of plaintiffs' claims and the court's orders, nor did they ever amend their complaint to challenge classification of FRTs other than the FRT 15 and WOT. Plaintiffs may not now expand the scope of the court's orders via notice after final judgment has been entered.
Yeah, we're gonna read the final judgment in a second, but let's just go ahead. We'll finish this.
Okay.
Actually, you know what? Let's go ahead and read the final judgment, just so everyone knows.
Wow. I wish I had this printed out and was able to diagram the sentence so I could understand what it is, and then point out the minuscule microscopic legal loopholes they're going after.
All right, let's go ahead and read the final judgment.
Let's see where you're starting. The court grants plaintiffs motion for summary judgment and denies defendants cross motion for summary judgment. The court vacates and sets aside defendants' unlawful classification of FRTs as machine guns. Now, it does say the FRT-15. It says FRTs. Boom.
It doesn't say the FRT-15 or WOT. It says FRT.
The court declares unlawful defendants' determination that FRTs are machine guns. The court enjoins defendants, along with their respective officers, agents, servants, and employees, from implementing or enforcing against the parties in this lawsuit in any civil or criminal manner described below the ATF's expanded definition of machine guns to FRTs. Now, that's generic. That's not product specific. That the court has determined unlawful initiating or pursuing criminal prosecutions for FRTs, initiating or pursuing civil proceedings for possessing, selling, manufacturing FRTs based on...
Just stop right there. One of the things that they said is, hey, you prosecuted 2 people for FRTs. And this says, can you read A again?
Initiating or pursuing criminal prosecutions for possession of FRTs. Now, FRT is an abbreviation for forced reset trigger, the generic version of a FRT-15 or WOT or Alamo 15.
Yeah. This guy, go to C.
Initiating or pursuing criminal prosecutions for representing to the public of potential buyers and sellers FRTs are not machine guns. Initiating or pursuing civil actions for representing to the public of potential buyers and sellers that FRTs are not machine guns. Sending notice letters or other similar communication stating that FRTs are machine guns. Seizing or requesting voluntary surrender of FRTs to the government based on claim that FRTs are machine guns. Destroying any previously surrendered or seized FRTs, and otherwise interfering in the possession, sale, manufacture, transfer, exchange of FRTs based on the claim that FRTs are machine guns. The scope of this injunction covers the individual plaintiffs and their families, the organizational plaintiffs and their members, the downstream customers of any commercial member of an organizational plaintiff, to the extent that it does not interfere with other courts, such as the Eastern District of New York civil jurisdiction over the rare breed parties, and pending criminal cases against individuals already subject to prosecution. The court further enjoins defendants from pursuing criminal proceedings or criminal enforcement actions against rare breed triggers, Lord Zamonico, Kevin Maxwell.
The rest really doesn't matter.
The court orders defendants to mail.
The rest don't matter. Let's just jump back into here.
Scroll back up because this one was important. The court orders defendants to mail remedial notices correcting their prior mailing campaign that warned suspect FRT owners. They
did do that.
Okay. This is a severe smacking their junk in the door hard and repeatedly.
All right, let's go back to here now.
Okay, so we're going back to the ATF non-response, blah. Finally, plaintiffs speculate that defendants are violating the injunction based on a government filing in the state court civil proceeding brought by an individual that the plaintiffs claim was involved in Rare Breed Triggers LLC formation operation where the government was not a party. Notice blah, plaintiffs are incorrect. In that case, the United States opposed a motion to compel production of communications between defendants' alleged confidential informants and an ATF special agent, arguing that the records sought were protected under the law enforcement privilege. And they cite case law, blah, blah. United States opposition to motion to compel responses and...
you can skip all that. That's all case law. Go down to plaintiffs.
Okay. Plaintiffs here claim that United States assertion of the law enforcement privilege establishes that there remains an ongoing federal criminal investigation of rare breed parties in violation of this court's injunction enjoining defendants from pursuing criminal proceedings or criminal enforcement actions against rare breed parties on the grounds FRTs are machine guns. Final judgment.
I'll read the next one. The United States, however, did not assert that there exists any federal criminal investigation ongoing after final judgment into rare breed parties predicated upon an assertion that FRTs are machine guns. Rather, it is recognized at the time of communications occurred, which long predated this litigation. They were made during the course of a criminal investigation. On the basis for ATF's assertion of law enforcement privilege, however, was pending civil enforcement proceedings, namely an in-rem civil asset forfeiture claim action in the District of Utah. The ongoing, basically what they did is they confiscated all of the stuff that Rare Breed was producing from their third party. An ongoing civil fraud case in the Eastern District of New York, litigation pertaining to Rare Breed party, blah, blah, blah. Okay. As defendants previously explained, these proceedings are carved out from the court's injunction, which is limited to the extent that it does not interfere with other courts, such as the Eastern District of New York civil jurisdiction over the rare breed parties. Nor does the assertion of the law enforcement privilege require prospective criminal proceedings. It is well established that law enforcement privilege may be invoked to protect civil proceedings. Accordingly, nothing in the United States submission indicates the existence of any ongoing criminal proceedings in violation of this court's injunction, and the defendant's actions are therefore consistent with this court's final judgment.
All right, can we get Cash Patel on the phone and ask why these people still have jobs?
Let's do it. I'm just joking.
Okay, so first off, it's amazing to me that somebody on the ATF has like, I don't know what, like tractor trailer flatbed size nuts to write something like this. And because there is so much twisting of the truth, misrepresentation of the truth, and just flat out, ignoring and I mean contempt of court, basically. Wow. So John and I have had this conversation a number of times that because what typically happens is GOA or any other gun rights organization gets a decision that their members and the members, so there's a couple of interesting things about the membership. One, they're not going to share the membership. Two, it doesn't matter when you became a member, before, after, during, doesn't matter. The timeliness of that does not matter. So then what that does is, if you let's just make it speeding tickets. Basically, you can't write speeding tickets because you don't know who the GOA or other gun rights organizations are, because you may not be legally allowed to do that and you don't have the information shared. So I've posted, well, you can't assume everybody is a GOA member, but basically it keeps you out of trouble by not writing speeding tickets in that case. And that's the same thing for FRT or whatever so this is an NAGR case. So NAGR members are specifically allowed to have FRTs.
Well, energy or anybody downstream of.
So if I bought a trigger from an NAGR member.
If you bought a trigger from an NRG member, you bought it from Rare Breed, you bought it from BDU back in the day.
So basically, that makes every FRT and WOT legal.
Yeah, basically,
because it has to be bought originally from BDU or Rare Breed.
Yeah, but it's more than that. I mean, anyone that touches it, like it would have to be, you would have to be able to trace back every single trigger to make sure it doesn't touch an NHR member or didn't have anything to do with Rare Breed or anything like that.
So it's kind of crazy that they would just go after this stuff,
Yeah, exactly. Exactly. It's really interesting, right?
And they're like, saying distinctions without a difference in cases, and it's like, guys, what is wrong with you? This is the kind of work. One, they use a lot of legal gobbledygook and gibberish. Legit, there's paragraphs in there. I literally would have to cross things out and diagram to understand what it meant. But they're saying that, we can't return them. We've made good faith efforts to return them. We were told, we destroyed things, but they were told not to destroy anything. They were told to return them. They were told to return. The initial judgment was to return in like the 30 days everybody that's a member of NAGR.
Yeah. Then it became, it's whatever. It's not cool. It's just not cool. But yeah, I think that's about it. Do you have anything else to say?
No, I mean, I legitimately would have to spend like a half hour on this document, like crossing things out and making notes, because there is a lot more here to talk about how disingenuous and what a bunch of freaking liars the ATF is in this case. Do we know that they've returned any triggers?
They set up a they set up like an email address you can email. I read an article about it on email and then but now they want you to do it's ridiculous.
But it's what when you confiscate something, it's evidence. You tag it, you make note of who you received it from, date, time, all of that. So they have all of this information. Now people move and all of that. Believe me, the ATF will find you if you move, if they want you. So them doing
If
this
they want to find you, that's the whole entire thing.
Yes.
If they want to find you, that is the whole entire thing, right?
Yeah, this
if
is
they
crazy.
don't want to find you, then they won't.
I just the balls that they have to just say like, well, loophole here, twisting truth here. Oh, you specified only rare breed FRT 15s. It's wow. The atomic size needle that you got to go through to make this work is nuts. It's just nuts.
Yeah. Exactly. It's not cool.
I mean, this is kind of Lord of the Rings secret supernatural power beat bullcrap that they're claiming. It's like, no, you're an agency that's on its way out, that's in its last dying breaths. You should not be doing this crap. And anybody that has their name on that document should be looking for a job today.
Yeah. Exactly. All right, guys. I think that is going to be it. We're going to get out of here, though. Thank you for watching. We'll be back later.
5 o'clock.
What the hell? Is everything locked up here?
Do I need to end it? You want me to end the stream?
If you can hear me, go ahead and end it.